I have more respect for a man who lets me know where he stands, even if he's wrong.
We always said in Black Panther Party that they can do anything they want to us. We might not be back. I might be in jail. I might be anywhere. But when I leave, you can remember I said with the last words on my lips that I am a revolutionary.
New Nubian.
Contracts I, Formation, Offer, Acceptance and Consideration. Presented by Dr. Jonah Sanders. Course objectives. To provide learners with a foundational understanding of how contracts are formed under common law, focusing on the principles of offer, acceptance and consideration. Course outline Module 1, Introduction to Contract Law Module 2, the Offer Module 3, Acceptance Module 4, Consideration Module 5, Case Examples and Application Module 6, Review and Quiz. Module 1, Introduction to Contract Law. Why contracts matter. Contracts are part of everyday life: buying a coffee, signing a lease, accepting a job, clicking I agree. Online understanding contracts helps protect your rights and responsibilities. Definition of a contract. A contract is a legally enforceable agreement between two or more parties, provides the legal right to enforce promises in court. Agreement versus enforceability. Agreement equals mutual understanding, legally enforceable equals recognized by courts. Not all promises are contracts. Types of contracts written, e.g. lease, employment offer, verbal, e.g. hiring someone for a task, implied, e.g. visiting a doctor. Everyday example scenario. Hiring a friend to paint a room for $100 offer. Friend agrees to paint. Acceptance. You agree to pay $100 consideration. Money exchange for service. This is a basic contract. Why it matters. Contracts are used to organize business and personal transactions. They protect rights and help resolve disputes, not just for lawyers or formal deals. Reflection, question. Can you think of a time when you made a deal or agreement that turned out to be a contract? Consider purchases, services, or promises. Think about whether it was enforceable. What's next? Next lesson. Legal versus social agreements deeper, dive into which agreements are recognized by law. Learning objectives. By the end of this lesson, students will be able to understand the distinction between legal and social agreements, identify examples of both types of agreements, analyze when a social agreement might become legally binding, understand how courts determine enforceability, introduction and definitions. Begin with a scenario. If your friend promises to buy you lunch and then doesn't, can you sue them? Define legal agreement. An agreement with intent to be legally bound, enforceable by law, social agreement. An agreement made in social or domestic settings, usually without legal intent. Key difference. Legal intent, courts enforce legal agreements, but not usually social ones. Characteristics and examples. Legal agreements characteristics. Intention to create legal relations, clear offer, and acceptance consideration capacity of parties. Lawful object social agreements characteristics. Informal setting, no legal consequences. Intended often lack clear terms or consideration. Examples. Comparison. Legal, a contract to buy a car from a dealer. Social, a dinner invitation between friends. Borderline, a roommate agreement about rent payments. Could be legally binding depending on evidence. Case studies. Case 1. Balfour versus Balfour. Husband promised wife monthly allowance while abroad. Court ruled it was a social agreement, not enforceable. Case 2. Merit versus Merit agreement made between separated spouses about mortgage payments. Court ruled legally binding due to changed relationship and written intent. Discussion questions. What facts changed the court's decision? Why was the second agreement enforceable? Class activity scenario sorting game. Present 8 scenarios and ask students to decide, is it a social or legal agreement? Should the court enforce it? Example scenarios. A person promises to pick up a friend from the airport. A friend sells another a used phone for money. 2 co-workers decide to split a lottery ticket. Summary and quando recap key takeaway. Not all promises are contracts. Courts look for intent to be legally bound. Social domestic promises are usually not enforceable. Borderline cases depend on context and evidence. Final question for reflection. When does a friendly promise become a legal commitment? Materials needed. Slide deck or board handouts with case summaries or printed scenarios optional. Video clips or dramatizations of court cases. Elements of a valid contract learning objectives. By the end of this lesson, students will be able to identify the essential elements that make a contract legally valid, explain the function and importance of each element, analyze real-life examples and case studies, apply the elements to determine if a valid contract exists. Warm-up and introduction. Ask the class, if two people shake hands and agree on something, is that a contract? Briefly explain that a contract must meet certain legal requirements to be enforceable. Transition. Let's explore the 5 essential elements of a valid contract. Overview of the 5 essential elements offer. A clear proposal by one party. Acceptance, unconditional agreement by the other party. Consideration, something of value exchanged. Intention to create legal relations. Both parties must intend the agreement to be legally binding. Capacity, parties must have the legal ability to contract. Use a visual chart or table to show these at a glance. Deep dive into each element with examples. 1. Offer. Must be definite and communicated. Example, I'll sell you my laptop for $500. Not the same as an invitation to treat. Two, acceptance must match the offer. Can't have changes or conditions. Example, yes, I'll buy it for $500 equals acceptance. Three, consideration. Each side must give something of value. Example, money for goods services. Can't be in the past. Four, intention to create legal relations business agreements. Presumed to be legally binding. Social domestic agreements. Presumed not to be. Example, a job offer versus a promise to help move furniture. Five, capacity must be 18 plus of sound mind, not intoxicated. Certain people may lack capacity. Example, a child buying candy versus a child signing a lease. Case study plus group discussion case, Carlyle versus Carbolic Smokeball Co. Company offered £100 reward for using their product and still getting the flu. Mrs. Carlyle followed instructions and got sick. Court ruled valid contract had all 5 elements. Discussion prompt. Identify the offer, acceptance, consideration, intention, and capacity in this case. Class activity, real or not real. Present short scenarios. Students decide if all elements of a valid contract are present. Example, Scenario 1, a 17-year-old signs a $10,000 contract, invalid capacity. Scenario 2, I'll give you $100 if you quit smoking. Is that legal consideration? Summary and quanda. A valid contract must have offer, acceptance, consideration, legal intent, and capacity. Missing one equals not enforceable. These elements help courts decide what's a promise versus what's a legal obligation. Materials needed, slides or handouts showing 5 elements, short case studies, or fact patterns, interactive quiz or group worksheet. Enforceability overview learning objectives. By the end of this lesson, students will be able to define what it means for a contract to be enforceable, identify key factors that make a contract enforceable or unenforceable, distinguish between valid, void, voidable, and unenforceable contracts. Apply this knowledge to real-life examples and case scenarios. Introduction to enforceability. Start with a question. Can every agreement be taken to court? Define enforceability. The ability of a contract to be upheld by a court of law, linked to earlier lessons. A contract must have all essential elements to be valid, but that alone doesn't guarantee enforceability. Factors affecting enforceability. Introduce and briefly explain 6 key factors that can affect enforceability. Legality of purpose. A contract involving illegal acts is void and unenforceable. Genuine consent. If consent is obtained through misrepresentation, duress, fraud, or undue influence, the contract may be voidable. Clarity of terms. Vague or ambiguous terms may lead to a contract being unenforceable. Form. Some contracts must be in writing. Oral contracts are often valid but harder to prove. Possibility of performance. If the performance of the contract becomes impossible, the contract may be discharged or become unenforceable. Public policy contracts that go against public morals or public interest may not be enforceable. Types of contracts based on enforceability. Valid contract. All essential elements present, legally binding and enforceable. Void contract, missing essential elements, has no legal effect. Voidable contract. One party has the right to cancel due to lack of genuine consent or capacity. Unenforceable contract appears valid but cannot be enforced due to technical reasons. Create a chart to visually compare these 4 types. Mini case analysis plus group activity. Scenario 1. A 16-year-old signs a phone contract. Later, he stops paying. Can the company sue? Discuss. Voidable due to lack of capacity. Scenario 2. A contract is made to divide profits from selling stolen goods. Discuss. Void due to illegal purpose. Activity. Give students 3 quick case examples and ask them to label each as valid, void, voidable, or unenforceable. Factors affecting enforceability. Start with a question. Can every agreement be taken to court? Define enforceability. the ability of a contract to be upheld by a court of law, linked to earlier lessons. A contract must have all essential elements to be valid, but that alone doesn't guarantee enforceability. Module 2. The offer definition of an offer. Learning objectives. By the end of this lesson, students will be able to define what an offer is in contract law, distinguish between an offer and an invitation to treat, identify the essential features of a valid offer, apply the definition of an offer to real and hypothetical examples, Introduction and engagement. Begin with a question. If someone says, "I might sell you my car," is that an offer? Transition. In contract law, an offer has a specific legal meaning, and not all proposals or advertisements are legally considered offers. Definition of an offer. Legal definition. An offer is a clear, definite, and unequivocal expression of willingness by one party to enter into a contract on specific terms, with the intention that it will become binding once accepted by the other party. Breakdown of the definition. Clear and certain terms. Must state the exact terms. Intention to be bound. The offerer must intend legal consequences if accepted. Communication. The offer must be communicated to the offeree. Key point. The offer starts the process of contract formation. Versus invitation to treat. Invitation to treat. A preliminary communication that invites others to make offers. It is not an offer itself. Common examples of invitation to treat. Items on store shelves or in advertisements. Auction listings. Restaurant menus. Case study example. Fisher versus Bell display of a flick knife in a shop window was not an offer, just an invitation to treat. Visual comparison chart. Offer, invitation to treat, can be accepted to form a contract, invitation to negotiate, clear intent to be bound, no legal intent yet, example, I'll sell you my bike for $200, example, product display in a store. Features of a valid offer. 1. Must be communicated. Silence is not acceptance if the offer was not clearly communicated. Definiteness of terms. The terms must be precise, subject, price, quantity, delivery, etc. 3. May be conditional or unilateral, e.g., I will pay you $100 if you find and return my lost dog. Revocable before acceptance. Offerer can withdraw the offer before it is accepted. 5. Mini quiz check-in. Is this an offer or an invitation to treat? Car for sale, $5,000 OBO. Call now, invitation to treat. Interactive examples and case application. Scenario 1. John says, would you be interested in buying my old guitar for $300? Not an offer, it's exploratory. Scenario 2. Sasha emails, I'll sell you my camera for $500. First come, first served. Clear offer, especially if addressed to one person. Ask students to explain why each is or isn't an offer. Requirements of a valid offer. Learning objectives. By the end of this lesson, students will be able to identify and explain the legal requirements of a valid offer, differentiate between valid and invalid offers, apply the rules to real-life and hypothetical scenarios, analyze legal cases related to defective offers. Introduction. Why validity matters. Engage students. What if someone offers to sell you their house, but they're joking? Is it a valid offer? Introduce the idea. A contract begins with a valid offer. If the offer is defective, no contract can form. Transition. Let's now examine what makes an offer legally valid. The 6 legal requirements of a valid offer intention to create legal relations offer must be made with the intention of being legally bound. Example, social conversations, legal offers. Case, Balfour versus Balfour, promise between spouses, valid contract. Definite and certain terms offer must be clear and specific, leaving nothing vague. Example, I'll sell you some shares at a good price, not valid case. Guthing versus Lynn terms like the horse is lucky, eeks too vague. Communication to the offeree. The offer must be actually communicated to the other party. No one can accept an offer they didn't know about. Case, reverses Clark, unaware of reward when giving Infos no contract. Offer must be capable of acceptance. Terms must be such that a clear yes can form a contract. Example, if conditions are incomplete or missing, it's not capable of acceptance. Compare with invitation to treat. Made by the offerer with serious intent to joke, hyperbole, or casual comment isn't a valid offer. Example, I'll sell you the Eiffel Tower at a bar, not serious. Courts look at objective intent, not hidden motives. Not terminated before acceptance. An offer that is withdrawn, expired, or rejected is no longer valid. Must be open at the time of acceptance. Leads into next lesson, termination of offers. Case study group activity divide class into small groups. Each group is given a brief scenario and must identify which requirement is missing or fulfilled. Examples, a father says, I'll pay you $100 if you clean the garage, but the child wasn't home or aware. Missing communication. A woman offers to sell her bike but says price negotiable, maybe $50 or $60. Missing certainty of terms. Groups share answers briefly with the class. Summary, recap the 6 essential requirements. Intent to be bound, clear and definite terms communication to offeree capable of acceptance, serious intent offer, not terminated, reinforce. A defective offer means no contract can form. Invitations to treat versus offers learning objectives. By the end of this lesson, students will be able to define and differentiate between an offer and an invitation to treat. Identify real-world examples of each. Explain why the distinction matters in forming legally binding contracts. Analyze case law where this distinction was central. Hook and introduction warm-up question. If a store puts a product on the shelf with a price tag, Is that a legal offer? Many people assume it is, but it's not. Introduce today's topic: the critical difference between an offer and an invitation to treat. Definitions and distinction. Definition of an offer: a clear, definite expression of willingness to be bound on certain terms, intended to be binding as soon as the other party accepts. Definition of an invitation to treat: a preliminary communication indicating a willingness to negotiate or receive offers, not legally binding by itself. Key differences: feature, offer, invitation to treat. Legal effect: can be accepted equals contract. Not binding: invites offers. Control: offeror controls terms. Receiver may decide to accept, reject. Timing: first step in contract precedes the offer. Examples: I will sell you X for $100. Displaying items, advertisements. Examples and applications. Examples of invitations to treat: goods displayed in a store. Fisher versus Bell flick knife in a window. Not an offer. Advertisements. Partridge versus Crittenden. Selling wild birds. Addy equals invitation. Not offer. Auction listings. Bids or offers. The auctioneer invites them. Price lists and menus. Informative, not binding. Examples of offers: I will sell you my bike for $150. Direct offer. Reward cases: Carlyle versus Carbolic Smoke Ball Co-ad with deposit, unilateral offer. Tip: use side-by-side comparisons to reinforce. Legal case exploration. Introduce and explain 3 landmark cases. 1. Fisher versus Bell. Shopkeeper displayed a flick knife in window. Court: display equals invitation to treat. Not an offer. Shopkeeper not guilty of offering for sale. 2. Partridge versus Crittenden. Ad in magazine offering to sell birds. Court: ad was not an offer, it was an invitation to treat. 3. Carlyle versus Carbolic Smoke Ball Co. Company promised £100 if their product didn't work. This was an offer, not just an ad. Clear, serious, with deposit to show intent. Ask class: what made Carlyle different from Partridge? Interactive scenario activity, group work, or class polls. Give students real-life scenarios and ask: offer or invitation to treat? Scenario examples: an online seller posts shoes $60. DM me. A job ad says now hiring full-time staff. Apply inside. A person says I might sell my laptop if the price is right. A supermarket advertises apples $1 kg while supplies last. Students must explain their answer and cite one reason or case. Recap and closing summarized. An offer is a serious, definite commitment that can form a contract when accepted. An invitation to treat is a pre-offer, asking others to initiate offers or negotiations. Why it matters. Knowing this distinction prevents false assumptions about enforceability. Vital in analyzing when a contract begins, especially in sales, employment, advertising, etc. Termination of an offer. Learning objectives. By the end of this lesson, students will be able to identify the various ways an offer can be terminated, distinguish between revocation, rejection, lapse, and other methods of termination, apply these rules to real and hypothetical scenarios, analyze case law that clarifies these rules. Introduction. Why it matters. Ask the class: can you accept an offer that's no longer available? Emphasize: an offer does not last forever. It can end through several methods. Transition. Today's focus is understanding how an offer can be legally terminated before acceptance. Overview of termination methods. Introduce the 5 main ways an offer can be terminated. Revocation, offeror withdraws of the offer, rejection. offeree declines the offer, counter-offer offeree proposes new terms, lapse of time expires without acceptance, death or incapacity of either party, failure of a condition required for the offer fails. Show a visual flowchart of how offers end before acceptance. In-depth analysis of termination methods. 1. Revocation definition. Offeror withdraws the offer before acceptance. Must be communicated to the offeree. Case: Dickinson versus Dodds. Third-party communication of revocation was valid. Limitation: offers cannot be revoked after acceptance or if consideration is given to keep it open. 2. Rejection by the offeree definition. If the offeree rejects the offer, it terminates. Once rejected, the same offer cannot be revived unless re-offered. 3. Counter-offer definition. A new offer made by the offeree in response to the original offer kills the original offer. Case: Hyde versus Wrench. Counteroffer terminated the original offer. Lapse of time. If no time is specified, offer expires after a reasonable time. Courts assess based on nature of transaction. Example: perishable goods versus real estate. 5. Death or incapacity. If the offeror or offeree dies before acceptance, the offer usually lapses, especially in personal service or one-on-one deals. Failure of a condition. If the offer is subject to a condition and the condition fails, the offer automatically terminates. Case study discussion. Scenario 1. Ali offers to sell his phone to Sam for $300, but withdraws the offer by text before Sam replies. Sam accepts the next day. Revocation is valid if communicated before acceptance. Scenario 2. Tina offers to sell her car for $5,000. Ray says, "I'll take it for $4,500. Counter offer equals rejection of original. Mini discussion. What if Ray later says, "Okay, I accept the $5,000. Original offer is gone unless Tina re-offers." Interactive activity. Termination sort instructions. Give students 5-6 short scenarios. They must identify: was the offer terminated? By what method? Examples: the offer was withdrawn after 3 days via email. The offeree says no, the offeror dies. The offer is accepted after 2 months. No expiry mentioned. Module 3. Acceptance definition and requirements. Learning objectives. By the end of this lesson, students will be able to define acceptance in contract law, identify the key legal requirements for valid acceptance, distinguish valid acceptance from counteroffers or conditional responses, apply the rules to real-world scenarios and relevant case law. Introduction and engagement. Ask the class. If someone offers to sell you a phone for $200 and you say, "I'll think about it," is that acceptance? Emphasize: acceptance is what finalizes a contract. Without proper acceptance, there's no agreement. Definition of acceptance. Definition. Acceptance is a final, unqualified, and unconditional expression of agreement to all terms of an offer by the offeree, which creates a binding contract. Essential characteristics: final, not a negotiation or counteroffer; unqualified, must accept the offer exactly as presented, communicated, must be properly conveyed to the offerer. Example: offer: "I'll sell you my bicycle for $100. Response: "I accept. Contract formed." Response: "I'll take it if you include the lock." Not acceptance. Counteroffer. Requirements of a valid acceptance. 1. Acceptance must be unconditional, no changes or conditions added. Mirror image rule. Acceptance must mirror the offer. Case: Hyde versus Wrench counteroffer terminated the original offer. Acceptance must be communicated. Silence acceptance can be oral, written, or implied by conduct. Case, Feldhaus versus Bindley, silence not acceptance. Acceptance must be made by the offeree. Only the person to whom the offer is addressed can accept. Offers to the public can be accepted by anyone who meets the conditions. Acceptance must occur. While the offer is open, offer must still be valid. Once terminated, the offer cannot be accepted unless renewed. Prescribed mode of acceptance. If the offerer specifies a method, it must be followed. If no mode is prescribed, any reasonable method is acceptable. Example, reply by post, only email reply may be invalid. Case scenario practice. Give students brief fact patterns to analyze whether acceptance is valid. A offers to sell a car for $5,000. B says, I accept if you add new tires. Not valid counteroffer. An online store offers a product. A customer clicks buy now and pays. Valid. Acceptance through conduct. A sends an acceptance by mail. Before it arrives, A tries to revoke it. Leads into next lesson. Group poll or class discussion to identify whether acceptance occurred. Communication of acceptance learning objectives. By the end of this lesson, students will be able to understand why communication of acceptance is required in contract law, identify exceptions to the communication requirement, explain the postal rule and its implications, evaluate how acceptance works via email, phone, online, or text, apply the rules to real-world scenarios and legal cases. Introduction and real-life prompt warm-up question. If I accept your offer in my head, but never tell you, is there a contract? Key takeaway. Communication is critical to forming a valid agreement in bilateral contracts. Transition to topic. Let's learn how, when, and by what methods acceptance must be communicated. General acceptance must be communicated. Legal principle. Acceptance must be communicated to the offerer for the contract to be complete. Silence generally does not amount to acceptance. Case example, Feldhaus versus Bindley. A nephew's silence about buying a horse did not amount to acceptance. The uncle couldn't assume agreement. Clarify. Verbal, written, or electronic communication is acceptable unless the offerer specifies a method. Exceptions. No communication required. Unilateral contracts. In some cases, performance equals acceptance. No need to notify the offerer. Doing the act is sufficient. Case. Carlyle versus Carbolic Smokeball Co. Mrs. Carlyle did not have to notify the company. Using the product as directed was acceptance. The postal rule definition. If acceptance is sent by post and it is a reasonable method, the contract is formed when the letter is posted, not when it is received. Applies only if post is a permitted method. The letter is properly addressed and stamped. Case law, Adams versus Linsell. A contract was formed when the acceptance letter was posted, even though it arrived late. Household Fire Insurance versus Grant. Acceptance effective when posted, even if it was lost in the mail. Limitations. Doesn't apply to instantaneous communications. Can be overridden by the offeror stating, only effective upon receipt. Instantaneous communication, general rule. Acceptance must be received to be valid. Modern cases. In Tors Ltd versus Miles Far East Court contract formed when acceptance is received, not when sent. Application to email text. Courts treat email like instantaneous communication, not like post. Acceptance via email text is valid when received by the offerer. Scenario-based group exercise. Provide students with scenarios to determine: has acceptance occurred? Is the postal rule applicable? What is the effective time of acceptance? Example scenarios. A mails a letter of acceptance on Tuesday. The offerer receives it on Friday. Postal rule. Acceptance valid on Tuesday. A sends an email acceptance on Saturday at 10 p.m. The office opens Monday. Likely valid when office is open and email is accessible. A says I accept but never tells B. Not valid, must be communicated. The mirror image rule learning objectives. By the end of this lesson, students will be able to define the mirror image rule in contract law, explain how it applies to acceptance, distinguish a valid acceptance from a counteroffer, analyze legal cases and apply the rule to real-life examples. Introduction. Why exact terms matter. Engage students with a question. If someone offers to sell you a phone for $500 and you say, I'll take it for $450, do you now have a contract? Introduce the mirror image rule. In contract law, acceptance must be a mirror image of the offer, no changes or additions. Definition of the mirror image rule. Legal definition. The mirror image rule requires that an acceptance must exactly match the terms of the offer. If it modifies, adds to, or qualifies the terms, it is not acceptance, it's a counteroffer. Key points: no new terms, no conditional language, no ambiguity. Case law explanation. Hyde versus Wrench facts. Wrench offered to sell land for £1,000. Hyde responded with £950. Wrench rejected. Hyde then tried to accept the original £1,000 offer. Held, no contract. The counteroffer terminated the original offer. Principle. A counteroffer acts as a rejection of the original offer. Stevenson, Jacques and Co. v. McLean facts. Buyer asked, will you accept payment in installments? Held. This was a request for information, not a counteroffer. Importance. Shows that not every response kills the original offer. Counteroffers versus inquiries. Compare and contrast. Response type, legal effect. I'll buy for $950 counteroffer. Would you consider $950 inquiry? I accept, but only if counteroffer. I accept. Can I pay next week? Possibly valid. Exceptions and modern developments. Some modern legal systems relax the mirror image rule, especially for commercial contracts. Under Battle of the Forms, differing terms may still lead to a contract, but common law still follows the strict rule. Scenario exercise. Mirror or not. Provide short fact scenarios. Offer: sell bike for $300. Response: I accept if you include a helmet. Not mirror image counteroffer. Offer: $500 for tutoring sessions. Response: would you accept payment in 2 parts? Inquiry: not rejection offer. Lease apartment for $1,000 a month. Response: agreed, but rent starts next month. Counter offer. Discuss answers as a class or in pairs. the mailbox rule and exceptions learning objectives. By the end of this lesson, students will be able to define the mailbox rule, understand when and how it applies to contract acceptance, identify major exceptions to the rule, analyze leading case law, apply the rule to fact scenarios, and determine if a contract is formed. Introduction. What happens when messages cross? Opening question. If you mail an acceptance on Monday but the offerer gets it on Thursday, is there a contract starting Monday or Thursday? Introduce the mailbox rule. A unique exception in contract law where acceptance is effective when sent, not when received. Definition of the mailbox rule legal rule. If an offeree accepts an offer via post, the contract is formed at the moment of mailing, not when the letter is received, as long as posting is reasonable. Requirements for the rule to apply. The mailbox rule only applies when acceptance is sent by authorized or reasonable means. The offer does not specify otherwise. The acceptance is properly addressed and stamped. The communication is not instantaneous. Case law support. Adams versus Linsell, the foundational case. Held. Acceptance is valid upon posting even if delivery is delayed. Rationale. Creates legal certainty and fairness for the offeree. Household fire insurance versus grant letter of acceptance was lost in the mail. A contract was still formed when the letter was posted, even though it never reached the offerer. Exceptions to the mailbox rule 1. Offer specifies acceptance upon receipt. If the offerer requires receipt, the rule does not apply. Example, your acceptance must be received by 5 p.m. on Friday. 2. Instantaneous communication phone, email, fax, text equal acceptance effective when received, not sent. Case. Torres Limited versus Miles Far East Corp. Telex message had to be received to be effective. 3. Revocation before receipt of acceptance. If the offerer revokes the offer before receiving acceptance, it can complicate timing, but contract is formed upon posting if the mailbox rule applies. 4. Improper use of post mailbox rule does not apply if acceptance is delayed due to wrong address, insufficient postage, unreasonable method. Application through scenarios. Give students 3-4 short hypotheticals. Ask, is the mailbox rule triggered? When is the contract formed? Scenario 1. A mails an acceptance letter on Monday. B receives it Thursday. On Tuesday, B sells the item to someone else. Mailbox rule applies. Contract formed Monday. Scenario 2. A sends acceptance by email on Sunday night. B reads it Monday. No mailbox rule. Valid when received. Scenario 3. A posts acceptance but uses the wrong zip code. Mailbox rule does not apply. Not properly addressed. Discussion. Fairness of the rule. Ask, is it fair that a contract can be formed before the offerer even knows about it? Some students may argue it protects the offeree. Others may say it's outdated in a digital world. Briefly discuss how modern courts and e-commerce have shifted away from strict application. Silence as acceptance. Learning objectives. By the end of this lesson, students will be able to understand the general rule that silence does not constitute acceptance, identify the exceptions where silence may form a contract, analyze relevant case law and hypothetical scenarios, evaluate the fairness and practicality of this rule in modern settings. Introduction. Is no answer a yes? Opening question. If someone offers to sell you something and says, if you don't say no, I'll assume you accept, is that legally binding? Most people think silence equals agreement. But that's not the rule in contract law. Introduce concept. In general, silence cannot amount to acceptance of an offer. General rule, silence, acceptance legal principle. Acceptance must be communicated by the offeree. The offerer cannot impose a contract simply by stating, "If I don't hear from you, I'll assume you agree." Case law Feldhaus versus Bindley uncle offered to buy nephew's horse and said, "If I hear no more, I'll consider it mine." The nephew did not respond, and the horse was accidentally sold to someone else. Held, no contract, silence is not acceptance. Rationale: protects individuals from being bound by inactivity, ensures mutual consent and clear agreement, prevents unfairness and abuse by offerers. Key exceptions. When silence may be acceptance, explain exceptions where silence may indicate acceptance. 1. Prior dealings between the parties. If the parties have a pattern of doing business where silence means consent, silence can equal acceptance. Example: a supplier sends goods monthly and the buyer routinely accepts without reply. Offeree indicates silence will mean acceptance. The offeree, not the offerer, may create a situation where silence is consent. Example: if you don't respond by Friday, I accept your terms. If the offeree sets this condition and the offerer agrees, silence may suffice. Unilateral contracts performance equals acceptance. No verbal response needed. Example: if you return my dog, I'll pay $500. Doing the act is acceptance without words. Implied acceptance through conduct. If the offeree accepts the benefit of the offer without objection, this may imply acceptance. Example: receiving services and not objecting or refusing payment afterward. Group activity, accept or not. Read the following scenarios and ask students: does silence amount to acceptance? Why or why not? Scenario 1, A emails B: I'll sell you my laptop for $500. If I don't hear by Thursday, I assume you agree. No acceptance, offerer cannot force acceptance by silence. Scenario 2, a gym sends monthly invoices and the client always pays silently. 1 month the client says nothing but still uses the facility. Yes, prior conduct implies acceptance. Scenario 3, A says to B, if you don't reply, I'll take that as a yes. B remains silent. No contract, silence alone is not enough. Scenario 4, a contractor performs agreed upon services without a written contract, and the homeowner silently watches and allows it. Yes, acceptance by conduct. Modern context, silence in digital contracts. Discuss how online platforms often use silence or inaction as agreement. Terms and conditions. Clicking I agree silence is explicit consent. Auto renewal contracts. Courts may uphold them if prior notice is given. Ask: Should courts allow silence in digital settings to bind users? Module 4, Consideration Definition and Function. Learning objectives. By the end of this lesson, students will be able to define consideration in contract law, understand the role and purpose of consideration in enforcing promises, identify examples of valid consideration, explain basic principles through foundational case law, introduction. Why can't a promise be enough? Warm-up question. If someone promises to give you $1,000 as a gift and later refuses, can you sue them? Answer. Usually no, because there was no consideration. Introduce today's focus. Consideration is what makes a promise legally binding. Definition of consideration. Legal definition. Consideration is something of value exchanged between parties in a contract. It can be a benefit to one party or a detriment to the other. Classic definition. A valuable consideration may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. Function of consideration in contracts. 1. Validates promises. Consideration turns a promise into a contract. Law does not enforce gratuitous promises unless something is exchanged. 2. Demonstrates intent to create legal relations. Shows that both parties are serious and have something at stake. 3. Acts as a bargaining element. Reflects the mutual exchange. I'll do this if you do that. Examples of consideration. Scenario: consideration present. Why? A promises to pay B $100 if B paints her fence. Yes. Mutual obligation. A promises to give B a car for free. No gift, no return promise. A promises to forgive B's debt if B does not sue. Yes. Forbearance equals consideration. Case study discussion case. Thomas versus Thomas. A man expressed a wish for his widow to stay in the house after his death. Executors allowed her to live there for £1 year. Held, £1 rent was valid consideration, even if nominal. Consideration can be small, but it must be real and legal. Group mini activity. Spot the consideration present. 2, 3 short scenarios and ask students. Is there valid consideration? Why or why not? A promises to give B a book for free. A sells B a bike for $50. A agrees not to sue B in return for $200. Discuss answers briefly. Legal detriment and benefit learning objectives. By the end of this lesson, students will be able to define legal detriment and legal benefit in the context of consideration, understand how either can support a valid contract, distinguish between a mere motive and actual legal detriment benefit, apply the principle to real-life examples and landmark case law. What is exchange in a contract? Discussion prompt. If someone promises to give you $1,000 and you do nothing in return, should that promise be enforceable? Answer. Usually no. Contract law demands something in return. Transition. We'll explore how benefit to the promiser or detriment to the promisee can make a promise binding. Definition of legal detriment and legal benefit. Legal detriment: doing something you are not legally obligated to do, or refraining from doing something you have a legal right to do. Examples: paying money, giving up a legal right. Legal benefit: receiving something you are not entitled to without the contract. Examples: getting money, getting services, goods, or a promise of support. Either legal detriment or benefit is sufficient to create valid consideration. Case law Curry versus Mesa definition from Curry versus Mesa. A valuable consideration may consist either in some right, interest, profit or benefit accruing to one party, or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. Break down what this means. Detriment to promisee or benefit to promiser equals valid consideration. Not about fairness, just about the existence of legal value. Examples and analysis: go through example scenarios and analyze. Scenario: legal detriment, legal benefit of valid consideration. A agrees to pay B $500 if B quits smoking. Yes, no. Yes. A promises to pay B $1,000 as a gift. No, yes, no, no. B agrees not to sue A if A pays $2,000. Yes, yes, yes. A promises to pay B for services already performed. Past action. No, no. Special concepts, key clarifications, moral obligations, legal detriment. Love and affection alone are not consideration. A promise not to do something you had no right to do anyway equals no legal detriment. Example: I won't burn your house down if you pay me. Not valid. You never had the right to do that. Group exercise: create your own Ask Students to draft. One example of legal detriment and one example of legal benefit. Let them share with a partner or in the class. Adequacy versus sufficiency of consideration learning objectives. By the end of this lesson, students will be able to define the difference between adequacy and sufficiency of consideration, explain why courts care about sufficiency but not adequacy, identify valid versus invalid consideration using real-life scenarios, analyze key case law. Introduction: fair price or legal value. Opening question: if someone sells a brand new car for $1, is that a valid contract? Most people think it's unfair, but in law, fairness isn't required. Today's topic: why courts only require legal value, not fairness. Definitions: adequacy of consideration refers to how much value is exchanged. Is the deal fair or proportionate? Courts do not inquire into adequacy. Even bad deals are enforceable. Sufficiency of consideration means something of legal value has been exchanged. The law requires consideration to be legally sufficient, not economically equal. Consideration must be sufficient but need not be adequate. Key case law 1. Thomas versus Thomas facts. Man wished for his wife to stay in the house after death. Executors allowed it for £1 per year. Held: the £1 was sufficient consideration even though inadequate. Principle: nominal consideration is sufficient if legally recognizable. Chappell & Co. versus Nestlé facts. Nestlé offered records in exchange for money plus chocolate wrappers. Held: chocolate wrappers had sufficient value even if trivial. Principle: anything of value, even wrappers, may be sufficient consideration. Adequacy versus sufficiency comparison table. Concept meaning court concerned. Example: Adequacy, whether the exchange is equal fair, no. $10,000 car sold for $100. Sufficiency, whether the item has legal value, yes. $1 rent, promise to paint a fence. Examples and student analysis, read each scenario. Ask, is the consideration adequate, sufficient, both, or neither? A agrees to sell a house for $10, buyer accepts. Adequate, sufficient, B promises to give C a phone for free. Adequate, sufficient, D pays E $100 for an old used chair. Adequate, sufficient, F agrees not to file a lawsuit in exchange for G's promise to apologize. Adequate, sufficient, discuss answers with reasoning. Class discussion. Should courts care about fairness? Do you think courts should intervene when contracts are unfair? Some may argue courts should prevent exploitation. Others may argue that autonomy and freedom of contract are more important. Tie back to policy. Courts protect bargains, not ensure good deals. Pre-existing duty rule learning objectives. By the end of this lesson, students will be able to define the pre-existing duty rule in contract law, explain why it invalidates consideration in certain situations, identify the exceptions to the rule, analyze relevant case law, and apply the rule to hypothetical situations. Introduction, getting paid twice, prompt. If a builder is already under contract to finish a house, can they demand more money halfway through? Intuition says no, and the law agrees. Today we study why doing what you're already legally bound to do is not valid consideration for a new promise. Definition of the pre-existing duty rule. A promise to do something you are already legally obligated to do is not valid consideration for a new contract. Principle. You can't promise the same performance in exchange for new compensation. There must be new or additional consideration. Case law Stilk versus Myrick Facts. A ship's crew agreed to complete a voyage. 2 sailors deserted, and the captain promised to pay the remaining crew more if they completed the journey. Held. The crew was already contractually bound to sail the ship. The promise of extra pay was unenforceable, no new consideration. Principle. Performing an existing contractual duty is not valid consideration. Modern exception, Williams versus Roffey Bros Facts. A subcontractor was falling behind. Main contractor promised to pay more if he finished on time. Held, promise was enforceable. The main contractor received a practical benefit, modern view. Other key exceptions. 1. New or additional duties. If the promisee does something beyond the original obligation, there is valid consideration. 2. Unforeseen circumstances. If something unexpected makes the original task significantly harder, extra pay may be enforceable. Legal duty to public. Performing a public legal duty is not consideration. Student activity. Apply the rule scenario 1. A firefighter rescues someone from a burning house. The homeowner promises to pay $5,000. Not enforceable, public duty already exists. Scenario 2. A builder contracted to finish a house by December 1st. On November 20th, demands an extra $10,000 or won't finish. Pre-existing duty, no new consideration. Scenario 3. A contractor agrees to finish the project early and hires more staff. Additional work equals new consideration. Past consideration learning objectives. By the end of this lesson, students will be able to define past consideration in contract law, Explain why past consideration is generally not valid. Identify the exceptions under common law. Apply case law and hypotheticals to test their understanding. Introduction. Can a thank you turn into a contract? If I fix your car without you asking, and afterward you promise to pay me, is that legally enforceable? Most people say yes, but in law, the act came before the promise. Today's topic: why past acts don't count as valid consideration. Definition of past consideration. Legal definition. Past consideration refers to something already done before a promise is made. Because the act preceded the promise, it cannot support a valid contract. A promise made in return for something already done is not enforceable unless an exception applies. Key case: Remacardle facts. A woman renovated her in-laws' house. After the work was done, they signed a document promising to reimburse her. Held, the promise was made after the act. No enforceable contract. Consideration was past. Principle. Consideration must be bargained for at the time of the agreement. Rationale: why past consideration fails. Contract law enforces bargain for exchanges, not gifts or favors. If there's no exchange at the time, there's no mutual assent. Prevents people from being bound by promises of gratitude. Exceptions to the Rule 1. Implied promise or request. If the act was performed at the request of the promiser, and there's an understanding of later payment, courts may imply consideration. Case: Lampley versus Braithwaite. A was asked to get a pardon for B. Afterward, B promised to pay. Held, the original request implied payment. Past consideration equals valid due to mutual intent. Commercial context or trade practice. In ongoing business relationships, a previous act can support a new promise if it was understood that payment would follow. Statutory exceptions. Some jurisdictions of the Indian Contract Act do recognize past consideration. Group scenarios: valid or not. Ask students to evaluate A mows B's lawn as a favor. Later, B promises $50. Past consideration: no prior request. A asks B to rescue her cat. B does it. A later promises $200. Valid: implied request and expectation. A repairs B's roof without telling B. B thanks A and promises $1,000. Not valid: no request. A always supplies B with goods and later asks for payment. Possibly valid in commercial setting. Promissory estoppel learning objectives. By the end of this lesson, students will be able to define promissory estoppel and explain its legal function, identify the elements required for the doctrine to apply, understand how it differs from traditional contract formation, recognize key case law and analyze real-world examples. Introduction. What if there's no consideration? Warm-up scenario. A landlord promises not to collect rent during a crisis. The tenant relies on that promise and spends the money on essentials. Can the landlord later demand the full rent? The answer lies in a concept called promissory estoppel, a way to enforce promises without consideration when reliance is present. Definition and legal purpose definition. Promissory estoppel is a legal principle that prevents a party from going back on a promise, even if there is no consideration, when the other party has reasonably relied on that promise to their detriment. Purpose: to promote fairness and prevent injustice, to protect individuals who act in reliance on a promise. Core elements of promissory estoppel. For the doctrine to apply, courts generally require these elements: a clear and unambiguous promise. The promisee relies on the promise. Reliance is reasonable and foreseeable. The promisee suffers detriment or injustice if the promise is withdrawn. Enforcement is necessary to avoid unfairness. Key case law: Central London Property versus High Trees House facts. During WW2, a landlord agreed to reduce rent due to low occupancy. After the war, he wanted full rent. Held, the reduced rent was binding during the war period. The landlord's promise was enforceable through promissory estoppel. Promissory estoppel suspended full rent during hardship. Key takeaway from High Trees: a promise intended to be binding, acted upon, and relied on is enforceable, even without traditional consideration. Application examples and student analysis analyze these situations. An employer promises to keep a retiring worker on a pension. The worker declines other offers. Likely promissory estoppel: clear promise, reliance, and detriment. A friend says, "You can stay in my apartment rent-free forever." Later, they evict you. Possibly not enforceable, courts look for commercial or serious intent. A supplier promises to deliver goods at a reduced price. The buyer doesn't seek alternatives and depends on that promise. Potential reliance-based enforcement. Limitations of promissory estoppel: cannot be used to create a new contract, only to enforce or modify an existing legal relationship. Usually operates as a shield, not a sword. May not apply in commercial settings if reliance is unreasonable or self-serving. Module 5: Case examples and application. Landmark cases: Carlisle vs. Carbolic Smoke Ball Co., Hamer vs. Sidway, etc. Learning objectives. By the end of this lesson, students will be able to summarize the facts, issue, and holding of key contract law cases. Understand how these cases illustrate key concepts like offer, acceptance, consideration, and enforceability. Analyze how courts apply legal principles to real-life facts. Strengthen legal reasoning and case analysis skills. Introduction. Why study case law? Start with a question. Why do we study old cases in contract law? Explain. Judicial opinions clarify rules and set precedents. Cases show how abstract principles apply to real situations. Transition to studying landmark decisions. Carlisle vs. Carbolic Smoke Ball Co. Facts. The company advertised that anyone who used the smoke ball as directed and still got the flu would receive £100. Mrs. Carlisle followed the instructions and still got sick. The company claimed there was no contract. Legal issues. Was this a valid offer? Did Mrs. Carlisle give valid acceptance and consideration? Holding. The ad was a unilateral offer to the world. Using the product as directed equal acceptance through conduct. Her action and suffering constituted consideration. Contract was enforceable. Takeaway: unilateral contracts can be accepted by performance, not just words. Offers can be made to the general public if clear. Hamer versus Sidway Facts. An uncle promised his nephew $5,000 if he refrained from drinking, smoking, and gambling until 21. Nephew complied. Uncle died before paying. Legal issues. Was the nephew's forbearance valid consideration? Yes, giving up legal rights was sufficient consideration. Even if the uncle didn't benefit, the nephew incurred a legal detriment. Takeaway: consideration doesn't need to benefit the promiser. Detriment to the promisee is enough. Additional notable cases give brief overviews of other influential cases. Ree McArdle, past consideration. A daughter-in-law renovated a house and was promised reimbursement afterward. Past consideration is not valid. Williams versus Roffey Bros, practical benefit. A contractor promised extra money to a subcontractor to finish work on time. Held. Promise was binding. Receiving a practical benefit can be valid consideration. Central London property versus High Trees House. Promissory estoppel landlord reduced rent during W2. Tried to restore full rent retroactively. Held. Landlord was estopped from going back on promise for the war period. Quick case application exercise. Present this question to the class. A company advertises it will pay $10,000 to anyone who uses its product and still contracts a disease. A user follows the instructions and still gets sick. Should the company pay? Let students apply Carlyle and discuss reasoning. Real-world examples in contracts learning objectives. By the end of this lesson, students will be able to identify how contract law applies in daily and professional life, recognize the elements of a valid contract in common scenarios, understand potential disputes and legal consequences in real situations, develop critical thinking by analyzing real-world contract formation, breach, and enforceability. Introduction. Contracts are everywhere prompt. How many contracts have you entered today without realizing it? Brief discussion. Buying coffee, downloading an app, using a streaming service, signing up for Wi-Fi, accepting a job offer transition. Contract law isn't just for lawyers or courtrooms, it's woven into everyday life. Business to consumer contracts. Example 1. Online shopping user clicks I agree on terms and conditions. Issues. Click wrap agreements, enforceability, hidden clauses, legal principle. Offer plus acceptance plus consideration through digital interaction. Mini discussion. Are people really reading what they agree to? Example 2. Buying a car buyer signs paperwork after inspecting the car. Later finds a major defect not disclosed. Issues. Misrepresentation, disclosure duties and warranties. Employment contracts. Example 3. Offer letters and job agreements. Job offers are binding contracts if accepted. Includes salary, role, benefits, and termination clauses. Discuss. Express versus implied terms, non-compete agreements. Severance and notice period scenario. Can an employer withdraw a job offer after it's accepted? Answer. Not without legal consequences. There may be a breach of contract. Business contracts and services. Example 4. Freelance service contracts a graphic designer, agrees to create a logo for $500. Client uses the logo but refuses to pay. Legal concepts. Unilateral versus bilateral contracts acceptance by performance remedies for breach. Example 5. Construction or renovation agreements. Homeowner hires contractor to renovate kitchen. Halfway through, contractor demands more money or walks away. Apply pre-existing duty rule and modification requirements. Group activity, contract spotting activity. Ask students to list 2-3 real-life contracts they've made in the past week. Examples may include subscriptions, gym memberships, food delivery apps, renting an apartment. Have students identify what was the offer, how did they accept, what was the consideration. Mini hypotheticals. Test your knowledge learning objectives. By the end of this lesson, students will be able to apply contract law principles to practical fact patterns, analyze whether a valid contract exists in different scenarios, evaluate possible defenses and remedies, engage in group-based legal reasoning and peer learning. Introduction. Why hypos matter explain. Hypotheticals train you to spot legal issues, analyze facts, and apply contract doctrines quickly, just like lawyers and law students do. Format. Students will read mini-scenarios, discuss in pairs or small groups, and share answers. Determine whether a valid contract exists, identify the issue, and apply the rule. Hypothetical Round 1. Offer and acceptance scenario 1. Alex tells Jordan, "I'll sell you my laptop for $300. Jordan says, "I'll think about it." 2 hours later, Alex sells it to Maria. Jordan calls the next day to accept. Questions. Was there a valid contract between Alex and Jordan? Can Jordan enforce the agreement? Answer, no, offer not accepted in time. Alex revoked by selling to another party. Scenario 2. Taylor posts online. Selling guitar for $150. First come, first served. Blake shows up and offers $120. Taylor refuses. Questions. Was that an offer or an invitation to treat? Is Taylor bound to sell? Answer. It's likely an invitation to treat, not a firm offer. No contract formed. Hypothetical Round 2, Consideration Scenario 3. Aunt promises to give her niece $5,000 if she finishes college. Niece graduates, then asks for the money. Aunt refuses. Questions. Is there consideration? Is the promise enforceable? Answer. Likely enforceable. The niece's action may be seen as consideration if induced by the promise. Scenario 4. Dev fixes Jamie's fence without asking. Jamie is grateful and promises to pay Dev $200. Jamie later refuses. Answer. No valid consideration. Past consideration is not enforceable unless requested beforehand. Hypothetical Round 3, Contract Defenses Scenario 5. Lee signs a contract while extremely intoxicated. The next day they want to cancel the deal. Questions. Is the contract void or voidable? Can Lee get out of it? Answer. The contract is voidable if Lee lacked capacity. They may rescind it once sober. Scenario 6. Carla agrees to sell her land after Max threatens to sue her for a false claim. She signs under pressure. Answer. This may be voidable due to duress. Consent was not freely given. Hypothetical Round 4, Miscellaneous and Group Challenge Scenario 7. You click I agree on a mobile app's terms without reading them. Later you're charged a $25 cancellation fee. Questions. Is the agreement enforceable? What concept applies? Answer yes. Click wrap agreements are enforceable if presented clearly, even if unread. Module 6, Review and Quiz. Recap key principles learning objectives. By the end of this lesson, students will be able to summarize the core principles of contract formation, recall key doctrines such as offer, acceptance, consideration, and promissory estoppel, recognize how defenses, case law, and practical examples relate to these principles, evaluate their understanding through a short quiz. Interactive recap contract. What is a legally binding agreement? Offer. What makes an offer valid? Acceptance. What are the requirements, including the mirror image rule and mailbox rule? Consideration. What is it? What's the difference between sufficiency and adequacy, pre-existing duty rule and past consideration? Why are they often invalid? Promissory estoppel. When does reliance make a promise enforceable? Defenses. Examples include capacity, duress, and misrepresentation. Use a whiteboard or slide with the terms and ask students to quickly define or give examples. Case law and real-world connections. Case principle. Carlisle versus Carbolic Smokeball Co. Offer and unilateral acceptance. Hamer versus Sidway. Consideration through legal detriment. Williams versus Roffey Bros. Practical benefit as valid consideration. Central London versus High Trees. Promissory estoppel. Multiple choice quiz 1. Which of the following constitutes valid consideration? A. Past favour. B. A. Legal detriment given in exchange. C. A social promise. D. A moral obligation. Multiple choice quiz 2. Which rule requires acceptance to match the terms of the offer exactly? A. Mailbox rule. B. Mirror image rule. C. Duress doctrine. D. Estoppel rule. Multiple choice quiz 3A. Unilateral contract is accepted by A. Signing a form. B. Speaking acceptance. C. Performing the requested act. D. Negotiating new terms. Multiple choice quiz 4. Under the mailbox rule, when is acceptance effective? A. When it is sent. B. When it is read. C. When it is received. D. When both parties agree. Multiple choice quiz 5. What makes a promise enforceable under promissory estoppel? A. Adequate consideration. B. Reasonable and detrimental reliance. C. Public duty. D. Written agreement. Multiple choice quiz 6. Which of the following is not a valid defence to contract enforcement? A. Fraud. B. Duress. C. Minority. D. Consideration. Multiple choice quiz 7 in Carlisle versus Carbolic Smokeball Co. Why was the promise enforceable? It was written. B. It was a clear offer accepted by conduct. C. It was advertised in a paper. D. The court ignored consideration. Multiple choice quiz 8A. Contract made while intoxicated is A. Always void. B. Voidable. C. Fully enforceable. D. Enforceable only with witnesses. Multiple choice quiz 9A threat to sue someone unless they sign a contract is an example of A, mistake B, misrepresentation C, duress D, unconscionability. Multiple choice quiz 10. If a person gives up a legal right at another's request, it is A, valid consideration B, moral obligation C, past consideration D, gratuitous promise.